Hi, my name is Paul Sardowski, president of HR Partners, a human resource consulting firm in Blairstown, New Jersey. We recently sponsored a webinar entitled What You Need to Know About the New New Jersey Equal Pay Act. I've gotten some feedback that said the webinar was too long and too legalistic. One of my favorite quotes is from Abraham Lincoln after he had written a 5-page letter to a friend of his. He put a PS down at the bottom that said, "Sorry, I didn't have time to write a shorter letter." Now, I've taken the time to shorten the webinar to a few minutes with a summary of its key points. I hope you find it useful. Here are the key provisions of the New Jersey Equal Pay Act. First, it applies to all New Jersey employers, regardless of size. That's much broader than the federal act. Monetary damages are significantly higher than under the federal equal pay law. Damages could go back 6 years from the date of the first discriminatory action. The law requires triple damages if found guilty. That significant monetary damages could encourage your employees to file with the Commission on Equal Employment or to take the company directly to court. The law requires a greater burden of proof on the employer. Under this act, the employee is only required to show that he or she performed similar work to an existing employee and was paid less. It is then up to the employer to prove that there was no discriminatory action. Pay comparison is much broader than under the federal act. The comparison is to, quote, similar work rather than the same job as under the federal act. This could mean a fair amount of complication in complying with the act. Other states have had laws with similar wording and are struggling with trying to define what exactly comparable worth is. Many companies have salary ranges, which include a number of different jobs in the same salary grade, even though the jobs are quite different and distinct. Could this be considered similar work under the statute? It could really be problematic for companies that use broadbanding with a large number of jobs in the same salary grade. The law prohibits employers from retaliating against any employee or discussing pay with any other employee. The law does allow individual pay differences based on job qualifications, education, and experience requirements for the job. I recommend that these qualifications and experience and education requirements be documented and be realistic. The law does also allow individual differences in pay increases based on performance. Again, however, I recommend that these pay increases be documented by specific examples of performance differences or measurable performance standards. Now, understanding the law and complying with it and modifying your policies to ensure compliance is only the first steps you need to take. You really need to look at whether you have inadvertent pay discrimination on the basis of sex, age, or ethnicity within your existing pay plan. I have found that many of my clients do not realize that they have inadvertently paid less to females and minorities. Doing this analysis is fairly complex and would generally require an outside expert like myself. HR Partners has had over 20 years experience in dealing with equal pay issues. We would be happy to help you figure out whether you are in compliance and whether you have some inadvertent discriminatory practices. Please give me a call if you have any questions on the Act or wish to talk about doing a equal pay audit. My phone number is 908-763-5699. Thank you.